But Indian team has a great hopes in badminton, boxing, and hockey. Those games are there, so still they are moving.
Oh, good. Well, good luck.
Thank you.
My face is not coming up clearly, so should I adjust or it will be adjusted from there?
This is fine.
Okay, it's not coming up properly in my thing. If it's fine.
This is fine as far as we are concerned. You have to only concentrate on your body.
ठीक है sir.
Welcome, Bharadeshwar.
Shivam?
I think now you can start, Manjula.
Okay, sir.
All the best.
Thank you. So welcome friends. So swagatam and namaskar to all of you, my friends, my colleagues and participants. I am Manjula Gupta, advocate on record and mediator in Supreme Court. Nivaran is not dependent on any introduction now. It has grown up and is a well-known name in the field of ADR and ODR. This is Nivaran's 5th International Summer School, conducted in collaboration with Commonwealth Lawyers Association and Singapore International Mediation Center. Till date, we have all gone through 7 interesting and useful topics, and today we are going to cover our 8th topic, namely mediation advocacy under the guidance of Mr. Duncan Turner, SC. The term advocacy is generally used in our legal profession as a skill. Therefore, advocacy used with the term mediation may sound a little, I'll say, unusual or say unheard of. For a lay person or say a casual observer, there may be an ambiguity in the term mediation advocacy. Mediation and advocacy may sound different to each other, but actually, in my opinion, they are not. Here the question may arise as to whose advocacy skill in mediation we are talking about. Mediation advocacy of mediators or the party's legal representative. How can a mediator and or party's legal representative be useful advocate both for mediation and in the mediation? Further, how do we conceptualize our role as an advisor in mediation? As a hero to solve the problems and win the case, or to step back and empower the client party to step forward while supporting and assisting in the mediation? There might be so many questions or say so many points or concepts about mediation advocacy and mediation advocacy, which are going to be answered by Mr. Duncan Turner, SC. Mr. Turner, who also does not need any introduction. He is well-known figure in this field. Mr. Turner is head of the mediation division at the Arbitration Foundation of Southern Africa. He actively promotes the use of mediation in the resolution of commercial disputes. And very recently, I've come to know that he is a great fan of cricket. He is a great fan of South India cricket team and Sunrisers of Indian team. And he used to play very well, but now, as he says, it has become his, still he has, I'll say, enthusiasm for cricket. So, without any further delay, I switch over to you, Mr. Duncan. Over to you, sir.
Thank you very much, Manjula. Good evening, everyone. From a very sunny winter's day in South Africa, I'm sitting in Johannesburg, and it is a great privilege to be invited to address you today. I'd like to thank the Navaran faculty, and a special thanks to Santhan, my friend who shares my love for cricket. I want to just remind everybody that in Africa, just as in India, communities have always understood the value of mediated resolution to disputes. And the use of mediation techniques is actually deeply ingrained in our traditional cultures. The calm head and the wisdom of a third party can make a massive contribution to repairing a relationship or rebuilding trust. And no doubt everybody listening to this lecture believes mediation should continue to be encouraged as a vital form of dispute resolution. Now, the question, I know that the Navaran faculty have addressed many subjects on mediation during this week, and the topic for today is mediation advocacy. And as Manjula has said, that might be interpreted as a slightly ambiguous term. Are we advocating for mediation, or are we advocating in mediation? And I'd like to suggest to you that both are legitimate and important topics. Now, I understand the majority of the audience today will be legally qualified. And so I'm going to spend some time focusing on the role of the legal representative appointed by a party to the dispute. But to remind them that in doing so, when you are appointed, you're an advocate for mediation and an advocate in the mediation. And although I'm directing this at legal representatives, I'd suggest that the principles and the approach that I'm going to discuss are really principles that can be applied by anyone involved in mediated resolution. So what is the role of the lawyer? Now, let's go back to first principles. When a dispute arises, a party will appoint a lawyer. And when the lawyer is appointed, the lawyer's training and his or her instincts will immediately respond to assess the information and work out the best method to protect and improve the client's position. Now, people who are trained as lawyers in our jurisdictions, they will normally have instincts to focus on positions. They will immediately consider their client's position, the position of the other party, and they won't immediately consider interests. And if the stereotype applies, as it does in so many places, the lawyer will consider his or her role to be the hero, to be the person required to take over, to command the ship, to lead the charge, to lead the defense. And this is the script of the traditional dispute resolution process. The details of the dispute and the documents are handed to the lawyer, and the lawyer then takes control of all matters. And often, the client believes that the only person who can get the matter to its conclusion is the lawyer. And so the client expects the lawyer to be the hero, and the lawyer expects that the client expects him or her to be the hero. And if we follow that role and we play out those roles, it's very difficult for the client to take back control of that process. So let's consider your role as a lawyer. When mediation is suggested, what will your role be? Will your role be to continue to perform the hero role? Or will you take a different role? Because I'd suggest to you that the role of the lawyer in mediation is different. In mediation, the lawyer has a very important role. It's to ensure that the client-driven nature of the process is maintained. The role of the lawyer is to facilitate the process to a successful resolution. And so my advice to you is, in mediation, the key contributions you can make are to empower your client and to assist the mediator. So what does that mean? What it means is consider the skills you're learning as a mediator, the things you've learned this week in particular. The key principles: focus on interests, not positions. Consider all relevant information. Assess the best alternative to a negotiated outcome, and the worst alternative to the negotiated outcome. You would have heard of the BATNA and the WATNA. Think creatively and maintain flexibility when you consider options. Now, those are all principles that you would have heard are principles that the mediator must consider when mediating the dispute. But I'd suggest to you, when you're appointed as the lawyer in the dispute, those principles are equally applicable. The unfortunate reality is that unless the lawyer makes that conscious decision to change his or her approach, the lawyer will continue to focus on protecting and improving the client's position, adopting litigation strategies instead of mediation strategies. And I'd encourage every lawyer to reconsider that approach. So let's just break it down. That's a general idea, and the general idea when you're approaching the dispute. But how do we break it down into the stages? I'd suggest to you there are three main stages in which the process can be considered. The first is the point at which mediation is considered. The second is the preparation for a mediation hearing, when you've decided to go to mediation. And the third is the mediation hearing itself. And I'd suggest to you that to remember at each stage, the lawyer's primary role is to be the helper, to empower the client, and not to be the hero. Now, we could deal with each of these in significant depth and for a long time. But in my experience, the lawyer can make a massive contribution to the success or the failure of a mediation. A lawyer that does not understand the goals and methods of mediation will focus on positions, and they will become the part of the problem. A lawyer that does understand the goals and methods of mediation will focus on the interests and the options and be a contributor to the solution. I'd like to also remind you as lawyers that parties to a commercial dispute seldom think that a legal answer is required before they can find a commercial solution. As lawyers, we often think that we need an answer before we can have a solution. We think that we need to answer the legal question or the factual question, or some particular preliminary issue needs to be resolved before we can move to the next point. And the reality is that commercial resolution and mediation generally will teach us that you don't. Very often, parties can find a solution without needing to know what the answer is. So I'd encourage you, even though your litigation training will kick in and you'll be looking for answers, always step back and consider whether you really need an answer before you can find a solution. Now, when do we mediate? And how do we mediate? And what are we looking for when I say we need to empower the client? Empowerment is really a question, in this case, of information and risk. And let me explain that to you, because it informs when mediation is going to be appropriate. In some cases, the best time will be when the dispute arises and before litigation starts. In other cases, the best time will probably be once the litigation has advanced to a more mature stage. Now, there will be some people, maybe even among the faculty, that would disagree with that. But I'd suggest to you that the real question is, when will parties be feeling to make a decision? So The following factors are the ones that I'm going to concentrate in this discussion, concentrate on in this discussion. First, the empowerment and authority of the client representative. Second, understanding the risk. Third, understanding the cost of alternative options. What do I mean by empowerment of the client? Well, if you're going into a mediation, who's going to make a decision? Why are they going to make a decision? And what do they need in order to make that decision? So when you're going into mediation as a mediation advocate, the first question is, who is your team going to be? You need to choose your team carefully. Very often, the person who's most involved in the dispute will be the person who's closest to the litigation. But very often, the person closest to the dispute may not be the best person to help resolve the dispute. You need enough information from the people involved, but you need the authority and the objectivity of a decision maker. Now, once you've got your team, how do you make that team feel empowered? I'm not talking about power to get leverage over your opposition or power to beat your opposition. I'm talking about power, the internal power within the team, the emotional strength and the confidence that the client representative will need to have when making a decision to settle. Knowledge is power. Power also resides in authority. Let me just use two examples to explain. My first example is a simple car accident. Assume Santhan and I both own our motor cars. We're driving our cars when a motor collision occurs between us. We appoint our lawyers to help us resolve our dispute. Now, in that situation, when would it be appropriate to mediate our dispute? When should we take our dispute to mediation? I'd suggest to you, you can do so almost immediately. Why? Because Santhan owns his car, I own my car. We have authority to make decisions in relation to the result. We were also there. He was in his car when the accident happened. I was in my car when it happened. So we both have knowledge of the circumstances under which the dispute arose. So with that dispute, the lawyer can assess my client has authority, my client has the confidence of knowledge in what happened, and now we can go off and we can see whether we can resolve this dispute. Let's contrast that with an alternative scenario where a patient dies in a state hospital. The widow then comes along as the potential plaintiff and appoints a lawyer. The hospital administrator then becomes the defendant in the case. Now, when can you settle that dispute? When the widow accuses the hospital of having done something wrong. In my view, you can't do it at the beginning. Why not? Because the widow doesn't really know what happened, and the hospital administrator doesn't know either. When will they be empowered to make a decision? The first question is knowledge of the facts. Let's consider it from the hospital administrator's point of view. They need access to the records, but they also need to know about the plaintiff. What are the circumstances of the plaintiff? How are the damages calculated? What's more, the hospital administrator will be subjected to a bureaucracy. If they make the bad decision, their neck may be on the line, their job may be on the line. And very often a hospital administrator would rather make no decision at all than be criticized for making a bad decision. So how do you get your client, the hospital administrator, into a mediation and give them the confidence to accept it, to go through the process? In each case, the lawyer has that role to make sure that if you are engaging in a mediation process, you are empowering your client to make a successful decision. A decision they can explain to whoever they need to explain it to, a decision that they can explain to themselves and be satisfied that it falls within their mandate. Now, let's assume that you have empowered your client. How do you approach the timing of that mediation? When is it the right time to make that decision? And I'd like to suggest to you that there is a relationship between knowledge or information, cost, and risk. And what you're looking to do as a responsible lawyer going into that process is to consider, when do we have enough information to make an informed decision? And if we assume that the end of a trial will give us perfect information, because then we'll have a judgment and the court would have told us what the answer is. And let's assume that during a trial, we learn more information. But we want mediation to take place before a trial and the costs, etc., are being incurred. And so when you have sufficient investigation done and sufficient information to make an informed decision, you're able to recognize that we know enough to assess the probabilities. We've reduced the risk of making a bad decision, and we're avoiding the costs of finding out the ultimate result. And so we are always considering the relationship between information, cost, and the risk of making a bad decision. And if you can apply that in your discussions with your clients going into the mediation, you then empower them to explain it to those who they have to explain it to. You give them a rational premise or a rational basis on which to explain the mediation process and the benefits of that mediation process. You give them the confidence to engage in their structures on why mediation is a good idea, and why in approaching the when approaching the mediation hearing, they will know what the different factors will be that will inform the decision they have to make. I'd suggest to you that if you don't give your client sufficient information, or you don't allow your client to feel empowered in going into that process, the likelihood of success in the mediation is significantly diminished. Now, I want to just highlight the fact that highlight what I have not referred to and what I've not highlighted. The first thing that I have not spoken about is the strength of my case. Very often, people consider that they need to consider the strength of their case before they can go into mediation. And that only if they have a strong case or a weak case. But the strength of the case is irrelevant. It's the knowledge and empowerment to make a decision. The second is complexity. You notice I haven't said to you that if it's a complex matter, it's suitable or unsuitable, or if it lacks complexity, it's suitable or unsuitable. Because mediation is suitable whether the matter is complex or not. The third thing that I haven't identified is the attitude of the parties to one another. Very often people would say, well, these two hate each other. They'll never settle. No point of going to mediation. That's often an excuse. It's a bad excuse. It's a bad reason. So let's just unpack those quickly. The strength of the case. Why would the strength of the case determine whether or not you should go to mediation? If you have a strong case, you'll hopefully come out with a good outcome. If you have a weak case, well, better you solve it now. So the merits of the case is not a factor that should detract from mediation. Complexity is only a factor in how the mediation is conducted. How long will it take? What would the process be? How you would engage the mediator and one another. But complexity is not a factor to prevent mediation. Third, the attitude of the parties. I think this is probably the worst reason that people rely on, because they misunderstand the benefit that mediation brings to the emotional stress and the emotional side of any dispute. Very often, it's the emotions, not the merits, that prevent resolution of a dispute. Once one gets into a mediation hearing before an experienced mediator, a mediator can often dilute the emotions, distract the parties from their emotional responses, or even allow the parties to ventilate their frustrations in a safe environment. It's very often the bottling up of the emotion which prevents the dispute from moving forward. And as a lawyer, you need to see that. You need to see that in your own client, and you need to see it in the client on the other side. And as uncomfortable as it might be, allow your client to be shouted at. Allow your client to shout at the opposition. And when I say shout, I mean in a sort of in a mediation setting. We often underestimate how the lay client considers the mediation hearing. As lawyers, we see a big difference between going to court and allowing a party to give evidence and going to a mediation in a private setting. But very often, just the presence of the mediator, when one client is able to vent and explain to the other side how angry they are and why they are angry, that often is enough to make that person feel that they've had their day in court. And once they've had their day in court, they're able to get rid of that emotion and allow the matter to proceed to resolution. And as a lawyer, you need to understand that. You need to understand that this process can unlock things that a litigation process can't. And if you have that understanding of the process, you are then so much more empowered to get your clients over the line in a successful mediation. So then going on into the second stage, preparation for mediation. What are you looking to do as the lawyer? Well, you've been briefed as the lawyer. You need to know what the legal position is. You need to understand the factual position. But your participation in the process, in the mediation process, unlike the litigation process, is not to put the client's best case forward. Putting the best case forward and then just vehemently insisting on that, which often happens in court, is an unpopular or it's an unhelpful method of approaching a mediation. What you need to do is to recognize how these wheels of the mediation are going to turn. And you need to add the grease to allow those wheels to turn more efficiently and smoother. The way you do that is to explore your client's interests beyond the specifics. Don't focus only on the forensic exercise of unpacking the case. Rather, understand the case, but unpack their interests going forward. What is it that they want? What is the nature of their relationship with the other party? What are the potentials? What kind of potential relationship could they have with the other party? How do they see the future rather than how do they see the past? That's the job you do with your client. The second part of that job is, who is the other side? who is going to be present from the other side? Sometimes you'll know, sometimes you won't. But who's likely to be there? What are their interests? What are likely to be the boundaries on what they can and cannot do? What does that firm or that person likely place a premium on? What are their key interests going forward? If you haven't understood that, how are you going to persuade them? How are you going to find a solution that you can sell to them? The third element is to understand what the mediator is going to require, because the mediator is the big wheel. What will be helpful to the mediator in understanding your client's interests, in understanding the interests of the other side, in understanding the nature of the dispute, but also the nature of the relationship? Because a mediator who is empowered to understand things as early as possible is far more equipped to help you find a solution than one who isn't. And I'll give you an example. I was recently involved in a mediation as a mediation advocate for a major oil company. There was one oil company on the one side and 7 oil companies on the other. It was a big infrastructure dispute. The one party had a particular problem and all the others were on the other side. I was in the room with the other 7 oil companies. I was briefed by one of the oil companies, but I soon saw that there was no cohesion between them. The mediator was due to come in, and I saw that you can't even start to engage with the mediator until you've found some kind of cohesion in the room with multiple parties. Now, my options were either to stand on my own client's rights and to try and get the most for my client, or it was to try to get some kind of cohesion in the room to assist the mediator, so that when the mediator came into the room with 7 parties, there was at least a cohesive channel of communication. So it's an example, but in the absence of finding how your room can assist the mediator in finding a solution is a massive benefit to the mediator. Otherwise, the mediator's got to mediate in each room before they can mediate between the rooms. And that just takes longer, is more difficult, far more difficult for the mediator to manage. So if you have gone in thinking about solutions which objectively can be justified, and you can present them to the mediator, either in confidential session in advance or during the mediation itself, you become of assistance to the mediator rather than an obstacle. I've spoken slightly about at the mediation now, when you're at the mediation process. But if I can just leave you with one more word in that process of preparation and in the process of being at the mediation, and that is trust. Trust is critical in mediation. Your client needs to trust you, and hopefully they do. Your client needs to trust the process, because if they don't, they're not going to trust the outcome. And you need to ensure that, as far as possible, the other side trusts that you are objectively engaged in good faith. If you can get trust right in this process, you are far more likely to get a successful solution as a mediation advocate than elsewhere, than if you don't. So we spoke at the beginning about advocacy for mediation. I've discussed with you advocacy in mediation. But I'd like to complete the circle and go back to advocacy for mediation. And the reason your advocacy in mediation is so important is because if you get it right, your client and the client on the other side, and probably the lawyer on the other side, will become converted to mediation. There is nothing like a successful mediation to drive the success of mediation as a practice. So I want to remind you that every time you engage in mediation, whether it is as a mediator or as a lawyer involved in mediation, you need to ensure that mediation itself is always the winner. Because the more successful mediations we can have, the more successful mediation as a process and a practice will be. I think that's a good place to end and to invite questions. Manjula?
Thank you, Mr. Turner. And my first question I'm asking myself, I have a doubt in my mind. When we say that this is advocacy, I have been taught from the very beginning that advocacy means preparation, presentation, and persuasion. So we are talking about preparation in the mediation, but where preparation and presentation, I agree that you are presenting yourself in front of the mediator as well as in front of your client and the other side also. Like you have said, you have very well said that other side should also have a trust in you that you are an objective person. But where is the persuasion? Persuasion, nobody can have persuasion in mediation. So when we talk about advocacy, don't you think that we are losing that part? And I just want to clarify myself.
That's a very good question. And I think that the focus of persuasion, it's still very much a job of persuasion. But this time you're not persuading an independent decision maker. This time you are persuading the other party. And in order to persuade the other party, you need to understand what that person's interests and objectives are. So when we as advocates go to court, the court's interest is to ensure as far as possible that they reach the correct and a just and fair outcome. So sitting as a judge or as an arbitrator, the decision maker will say, I'm listening to the evidence, and my interest as arbitrator is to come to the correct result. And that's the object of your persuasion. But when you are going into mediation, you're not going to do so by persuading the mediator. The mediator may be completely convinced that you're right. But if you don't get the other side to recognize the benefit of the solution, you're not going to get a mediator solution. And so the focus of your persuasion is to work out what will convince them that resolving it by agreement rather than going back to litigation is the most important outcome. So it's just a different hat. It's the same role, you've got a different focus.
Okay. And what will be the role of a mediator in that mediation advocacy? Will that be on the other side, he'll have a little backside role, or how will you say that, what is the role of mediator in that?
No, the mediator must perform the role of the mediator. So the mediator, of course, has a very important role. Sitting as mediator, you're going to listen to both parties. You're going to engage with both parties. You're going to have the confidential sessions with the parties. So the role of the mediator is critical. But today, we're looking at the advocate in that mediation, and the advocate who understands what the mediator's role is and how he or she as advocate can persuade the mediator or give the mediator the materials to persuade the other party is a critical role. And never underestimate the importance of listening rather than talking. Somebody said to me once, and I've always remembered it, they said, We were given one mouth and two ears. We should use them in those proportions.
Thank you very much. The next question is asked by Suvarna S. Ganu. This is sometimes when a client is referred to mediation mid-litigation, she views the process as a delay tactic and has no intention to negotiate. When this is communicated to the advocate, how should the advocate advise the client?
Yes, that's a common problem. But again, that's the issue of the attitude. And so the question is, what do you need? What do you, the client, need from this? Do you need a resolution? Or do you need to inflict pain and consequence on the other side? Because if you need resolution, mediation will give you resolution just as well as anything else. Because if you really consider the process, and this is, I think, where I get very frustrated with many lawyers, is that they have no problem settling a case on the doors of court. So they will take 3-4 years to get to court and refuse and say, there's no chance to settle. There's no chance that the parties can resolve this matter through negotiation. And then that very same matter between the very same people is settled on the morning that you're about to go before the judge. Now, if that can happen, and it happens as often as it does, then there was no excuse for not doing it earlier. And so it's getting that thinking into the mind of the client and the lawyer to say, well, is this a matter is this a hill you're going to die on? Or do you recognize that when the reality of the court faces you, you will be prepared to settle? Because if that's your approach, I'd suggest we do it on our terms and in a controlled and mediated environment, without spending all the costs we're going to spend to get there.
Now, the next question is, the glory that litigation is said to bring to an advocate sometimes blinds him/her when it comes to mediation. How do you look at the apathy of the lawyers towards mediation?
Yes. Well, glory comes in success. What comes with failure? Because I've got books behind me. Every single one of them had parties on both sides. And there were lawyers on both sides. There was always a lawyer for the losing party as well. Now, I have a very strong belief that the ethical obligation of a lawyer is to do what's in the lawyer's best interest, to do what's in the client's best interest. That's a Freudian slip. And to do what's in the client's best interest is to find the best solution for that litigation. But I'd like to add something. I think I said it in the seminar last year as well. A successful lawyer is not determined by a single case. A successful legal practice involves building up a client base who believes in you, trusts in you, and is a repeat business. They whenever they have disputes, they trust you to help them resolve those disputes. And so my advice to young lawyers is, don't look for glory in one case. You need to sustain yourself for the rest of your life. And the best way to build and sustain a legal practice is to get repeat customers. And the way you get repeat customers is to find the best solution to each dispute, not to look for glory in a single dispute.
Now, the next question is from Annapurna. She's appreciating and asking the question. I'll read the whole. A wonderful and a highly nice presentation, Mr. Turner. Enjoyed this very much. One question that popped in my mind when you were discussing that the merits of a party's case and its strength in court does not matter for initiating mediation, but would not the strength of each party's vatna and mitigating the effects of their vatna, that is inter alia, the strength and or weakness of their cases in court, have a significant impact in the settlement outcomes in the mediation? To
Yes,
that
I think
extent,
yes, sorry.
To that extent, would not the Bhatna and Vatna have an impact on the timing of commencing mediation?
Yes and no, because you're going to have a Bhatna and Watna at every time, at wherever you are. So I would suggest that the Bhatna and Watna is an assessment that you are always going to do, but it's not a reason not to mediate. It's how you mediate. So the Bhatna and Watna will inform how you mediate rather than whether you mediate. And just to tell you, for example, on the merits, give you an example of why I say the merits don't matter. We are successfully mediating claims by banks in relation to debt. Now, if you think about a debt owed to a bank, it's normally factually very easy to resolve. The bank can prove that the money was borrowed. The lender hasn't repaid the money. So where's the dispute? I mean, normally that's a relatively straightforward merits claim. You could go to court and get your order. But sometimes the client has an excuse or some kind of contractual defense, or the lawyers come up with some defense, which probably has no merit, but the court's still got to have a listen to it. Now, the banks have seen a benefit in mediating those disputes. Why? Because the result of that dispute can often be and I don't know whether you have it in India, but we can have an acknowledgement of debt. An acknowledgement of debt is a liquid instrument that the bank can then use in a very simple court procedure to enforce it. So through mediation, what the bank secures is an acknowledgement and a simplified procedure to enforce it, if necessary, later. What the client gets is a hearing and a little more time to try to discharge the debt. So on the merits of the underlying dispute, there's no debate that the bank is owed the money. But in resolving their respective interests, the client gets a bit more time and the bank gets an easier process to enforce the debt. So there's an example of why the merits are not necessarily a reason not to mediate.
Thank you, sir. My next question is, it has been asked by Swati Padnekar. What are the skills which differentiate between mediator and mediation advocacy?
I think they are similar skills. The listening skill is a critical skill. The objective approach is a critical skill that is shared. It's how you employ them, I think, that is the difference. When you are a mediator, you're going to be doing it with a mediator's hat on to try to find people and listen without an agenda. When you are a mediation advocate, you are engaged in the process with an agenda. Your agenda is to get your client over the line and to persuade the other side to agree to terms that your client would be happy with. So the skill set is similar, but you employ them in a different way.
The next question is by Suvarna Jain. Sometimes while empowering the client to face mediation, the clients are just tutored and they're quite adamant during negotiations. How to deal with it?
Yes, we've all been there. I think that it's a process and personalities are always critical. My best advice is to listen. My best advice is to listen carefully and listen between the lines. So don't listen only to what they're saying. Listen to what they're not saying. And try to understand why it is that they're taking this position. Because once you understand why they're taking that position, you may be able to unpack it and get them across the line.
Thank you. And the next question is?
I see Erica's got her hand up.
Sorry? Am I audible?
Yes, sorry, carry on, Manjula.
Yeah. So the next question is, when one party gets a lawyer, but the other party objects for third-party intervention in their dispute, except a mediator. In such a situation, can the lawyer be asked to go out, or what should a mediator do to encourage mediation?
That is a tricky one. Remember, mediation is a consensual process. So if the party without a lawyer objects and says, I'm not participating if the other side is represented, then they're not participating because you can't force them to do so. So as a mediator, my experience is the best way to do it is to understand why the party with the lawyer wants the lawyer, and to understand why the party without a lawyer, number one, objects to it, and number two, doesn't have his own lawyer. And if you listen to both parties as to their reasons for adopting the position, you'll hopefully be able to find a solution. Sometimes the solution will be for the unrepresented to get a lawyer. Sometimes the solution will be to get the represented party to understand that they won't be compromised if they come without a lawyer. So you've got this, you need to understand, you need to listen. What is the concern and how do we fix it? We either bring one in or we take one out. But again, that works when the parties develop a trust in the mediator.
And the next question is by Parthasthi Mandadi, maybe I'm pronouncing wrongly. Certainty of outcome is assured in all legal cases. To what extent such certainty of outcome in terms of solution in mediated cases can be estimated? Can I read it again?
No, I'm just thinking about the certainty. I would think that certainty is almost always achieved with greater clarity in mediation than in litigation. Now, as unusual as that sounds, remember, where you successfully conclude a mediation, you will record it in an agreement. There will be a written agreement that will resolve your dispute and legislate your way forward. If you are careful in the way in which you record that agreement, you have certainty and you have it early. And whereas litigation, you may have certainty. Well, first of all, you don't have certainty to tell you what the judge or the arbitrator tells you what the answer is. If there's an appeal process, you still don't have certainty until the appeal court or the appeal tribunal tells you what the answer is. You can legislate for your own certainty in mediation. And so a successful mediation will give you that certainty early and allow you to carry on with your lives.
Next question is by Sabhyasachi. As a mediation advocate, how do we assess possible bias in the mediator during mediation session and how to turn them into my client's advantage?
I'll ask you this question in response. Do you want your mediator to be biased? I would suggest to you that it's not in anybody's interest to have a biased mediator. Your prospects of certainty, we talked about certainty in the last question. Your prospects of certainty are seriously undermined if you have a mediator with bias. Because the one way in which a mediated outcome will be undermined and set aside is if it turns out that the mediator breached the trust placed in him or her. A mediated outcome works because the mediator has that level of trust and has that level of objectivity and independence. So I would advise you against attempting any bias, attempting to achieve any bias in a mediator.
The next question is by Shefali Roy. Mediation certainly is a process where the mediator wants disputes to be resolved amicably. However, many a times we see the ego clashes as the clients at dispute get stuck around the win-lose situation as it happens in the court. How does one deal with that kind of thought process? Adamancy and sort of rivalry during mediation and try to eliminate such belief?
I think that lies in the skill of the mediator. An experienced mediator will be able to read the room. An experienced mediator will be able to see the nature of the dispute between the parties and understand the nature of the personal animosity or the egos or the history involved. And in each case, the mediator will find the solution they think most appropriate. In some cases, sitting as a mediator, I've had the parties sit with their lawyers and have the lawyers argue at each other. In some cases, I haven't even had a combined meeting. I start the meeting in separate rooms. They don't even see each other. In yet other cases, you have only the parties represent. The lawyers may be present in the mediation, but I invite the two leaders, the two CEOs or whoever they are, just to meet me privately. So in each case, you will need to assess the parties, assess the case, and make a decision. Manjula, I see Erica has a hand up. She's on the screen and she's trying to. Erica, can
Mr. Duncan, Mr. Duncan Turner, thank you so much, Mr. Turner and Manjula Guptaji, Dhanyavad, thank you. I have 3 questions, so perhaps I would like to ask you kindly to share your email address or any form of details which you would be able to. My first question would be evidence use in mediation. Is there any guide or any international guideline towards how to use the evidence in mediation? The second question is related to South African Constitution. We were very lucky to have Lady Justice Alu of Kenya, and she kindly mentioned Article 159 letter C of Kenyan Constitution. So perhaps you can mention, is there any reflection of the ADR access in a South African Constitution? And my last question would be, what you have mentioned with the relatively straightforward cases with the banks and the client dispute, what you would do if you would have a client which has the first creditor as a bank and the second creditor on the property would be a private natural person. If the second creditor would like to pursue the claim, the bank's reaction was that at the moment the client's paying, therefore the property cannot be sold. So how to settle or how to make the debtor to try to sort of move on to pay the creditor number 2 if the creditor number 1 is still satisfied? Thank you.
Yeah, America, we may need to correspond separately, but let me deal in general terms with evidence. The key about mediation is that it's a confidential process. And so the concept of evidence is a very different concept to what we have in courts or in arbitration. Again, coming back to Manjula's first question, we're here to persuade the other side to agree to something with us. And so the evidence that is relevant will be the evidence that you think will be persuasive to get the other side to agree with you. It's not a question of admissible evidence or evidence to convince a third party. When you assess the evidence to be debated, you're doing so only in the context of showing the other side that this evidence exists, and they would be well advised to recognize the strength of the evidence and settle with you. And so let me leave it there. I don't want to hijack Manjula's Q&A because I think we're almost out of time.
My next question is, so Divyansh is asking this question. He says, when, as you have said in your today's conversation, that lawyer has to participate actively in mediation process. So his question is, when you say that if the lawyer actively participates in mediation, pre and post, whatever, whether it will be not considered as if he has overpowered this client in mediation proceedings?
Yes. I think that's exactly what you want to avoid. So you're right. That risk is a very real risk, that the lawyer becomes what I call the hero. So that was at the beginning of my talk, I said, try to recognize that in mediation, the lawyer is not the hero. And so make your client the hero. When you go into mediation, recognize that the mediation process should be a client-driven process, because it's the client that's going to sign the agreement at the end of the day. And work out how you can get your client to participate and be the active ingredient in the final solution. So you're a facilitator of the process rather than the hero in the process. I think that's a very good warning, that you must recognize that as the lawyer, you do have power, you do have the ability to dominate, and you need to restrain yourself and ensure that you listen more than you speak.
My next question is it's from Swati Jain. She says that when you say that you have to know the intention of other side party and his advocate and whatever. So he says, even if you know, how will you take into your advantage that? How will you use that in your client's favor?
Well, let's first consider what my advantage would be. What is it that, what am I exercising an advantage to achieve? Remember, I'm not trying to win. I'm trying to get a settlement. So how do I use what the other side, what I know about the other side, how do I use that to succeed? Well, if success is a concluded agreement, my ability to use their interests to persuade them to my client's best interest is the persuasion that I'm trying to achieve. So let me take an example of a commercial dispute where I know that the other side is a trader, my client is a farmer. I know that the trader wants access to my client's produce every year. At the moment, we are fighting about what happened last season and whether or not the price was right or the goods were delivered. That's what the fight is. But I do know that that trader next year will be looking to sell produce. So while the other side might have my client may be in fault. Maybe my client is unlikely to win, is likely to lose in the case. But I know that if that trader can have access to my client's produce next year, they have the security of a deal or whatever going forward. Now, if I didn't know that that trader was interested in me, I wouldn't have that option. But once I know who they are, and what their future interests are, I can find a solution to the current problem by solving it with a future interest. So it's that type of interest that you need to understand from the other side, which then broadens the opportunities for resolution.
My next question is, Mr. Turner, whether this mediation advocacy is important in commercial mediation only, or it is equally applicable in all the other mediations?
I think, yes, I think it's important in all. You need to tailor your approach depending on what you're doing. But mediations, where lawyers are involved in mediation, you're either part of the solution or you're part of the problem. And make sure that whenever you're an advocate or whenever you're a legal advisor in a mediation, try to make sure that you're part of the solution, not part of the problem.
And the next question, sir, has been asked by Mr. M.A. Jabbar, advocate from Cochin. He asked, have any international accreditation platform for a mediator?
Sorry, I missed the first part of that question.
Is there any international accreditation platform for a mediator? Mr. M.A. Jabbar is asking.
Sorry, an internet platform. So I couldn't hear the part of the question. Something for an international something for mediators.
International accreditation platform he's asking about.
Extradition.
Yeah.
I'm afraid I don't understand the question.
No, he's talking about accreditation.
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 Yes.
Oh, international accreditation. Yes.
Yes.
Yes, there is international accreditation. There are a few organizations that offer it. I know the Singapore, I think Singapore offers it to their arbitrators, and I think they're developing a course for their mediators. I know that the CEDA in London is an international accreditation, and there are one or two in America. In South Africa, we are developing one, and hopefully by next year we will have an international accreditation available in South Africa.
So, sir, I think it's a time to. There's no such other question, sir. On my screen, if anybody has, please let me know about that. Or anybody wants to ask the question, they can raise the hand.
Manjula, I have put a question in the chat box. Can you just read it, please?
Just a minute. Let me see. Yeah. Sorry, Nandini, I just missed it.
No problem. Thank you.
Nandini Guru is asking, we all are lawyers and some of us become mediators. How to and up to what stage I should use my advocacy skills for the benefit of the mediation process per se?
I think we should always use it. Sometimes people look at me askance when I say so, but as an advocate, my practice is in large, complex disputes. I arbitrate big fights for telecoms and oil and gas, and where often the clients and the lawyers involved think these are intractable. We're never going to be able to resolve them. They're too big, they're too complex, the people hate each other too much. And my advice to them in every case is, let's see whether we can mediate either all of it or part of it. And the other thing I would encourage you to do as part of the mediation community is to not be too precious about sharing the love. I find as lawyers, we developed, particularly young lawyers, always worried about their clients and losing a client and allowing their colleague to get the limelight when they could get the limelight. In mediation, we need to build a community that is mediating all the time. And the way we do that is to support and encourage our fellow mediators. And so if you are a qualified mediator, you want work, but the best way to get work is to refer your cases to your colleagues. Because if you give your colleagues support, the likelihood is that you'll get it back. Or even if you don't get it back directly, mediation as a practice will grow, and your involvement as a mediation practitioner will bring you more work. So if we grow the community and we constantly promote mediation, there will be more mediations. So I would really encourage everyone to do it and do it as often as possible.
So thank you, Mr. Turner. Thank you very much for replying all the questions in such a simple and effective manner. that I think probably everybody would have understood easily. And they will, of course, be very useful for us to use in mediation, our mediation. I thank you on behalf of myself, Team Nivaran, and participants for enlightening us on mediation advocacy in such a crisp and candid manner. Thank you very much, Mr. Duncan Turner. A big thanks to the participants for joining this session today with such an enthusiasm, and that too on the Saturday evening. Big thanks to all of you. Big thanks to all of you from my side as well as from the side of Nivaran team. My heartiest thanks to Team Nivaran. I'm grateful to Nivaran for giving me this opportunity to host today's session. Thank you very much, Team Nivaran. Thanks from my heart. And I thank everybody. Last but not the least, I convey my thanks to Rahul and his team for providing us his tireless technical support. Without his team, I don't think so we'll be able to conduct this summer school in such a beautiful way. And with the great pleasure, I invite all of you to join another interesting topic, Singapore Convention on International Settlement Agreement, tomorrow, with full of your enthusiasm and spirit as you have shown today. The session will be hosted by Mr. Devrat, and the guest speaker will be Chitra Narayan, lawyer, senior mediator, and the author. Once again, thanks to all of you. Thanks from my heart. Enjoy Saturday evening. Namaste. Namaste, good evening, and goodbye. Thank you very much.
Thank you, Manjula.
Thank you, Duncan.
Thank you, Mr. Turner.
Thank you very much. Bye-bye, everyone.
Thank you, Duncan, for such a nice one. It's a very elaborative and very detailed one.
Jitendra, nice to meet you, and I'm glad you enjoyed it.
Thank you so much. Thank you, Manjula.
My pleasure, sir.
Yes, you did perform very well. Thank you so much.
Thank you very much. Bye-bye, everyone.
Bye. Till we meet again.